Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. The maritime law as environmental protection, the management in study case of sustainable operation to control emissions in maritime transport in ACS area part 3. A state by IHS Maritime 2014, based on the global financial crisis and rising oil prices, there were organizational changes to the maritime sector, and Danish ship owners began to examine alternatives for new ways to reduce fuel consumption in their activities production of maritime service. However, the period of disposition was too short as Maria Brun Skipper, 2014, senior advisor of the Association of Danish Ship Owners. The measures of this most intense phenomenon occurred in the period between 2008 until 2013, when the Danish ship owners needed at any price out CO2 emission by almost 50%, and it was necessary to incorporate a new fuel technology vessel. Since then, the Danish ship owners are studying how to keep reducing the environmental impact and sustain an ecologically balanced environment by controlling emissions. Henceforth, in this particular ship owners has shared their technological methods to control fuel consumption. This practice successfully enabled encouragement the shipping eco-efficiency in management system that enable the best way to control atmospheric emissions, mitigating technological measures on the high seas. However, it is necessary ongoing investments in several laboratories to support the fuel quality analysis. It currently seeks to finance the purchase of technologically sustainable fuel, usually one that has low sulfur content. For this purpose, some ship owners from January 1, 2015 began to charge its customers as a surcharge to comply with an environmental standard of low sulfur emissions. This surcharge arose from an environmental standard which was generated as a result of public measures to the maritime sector, allowing more satisfactory environmental change in terms of emissions. Accordingly, there are geographical boundaries for the performance of activity on all cargo transported or to be transported from the port of shipment, even for transshipment and or final destination operation, provided that these rules present is limited to the territorial sea, economic zone exclusive, inside the perimeter delimited emissions control areas or ACA, in North American and other areas signatories of this legislation in other countries. The low sulfur emissions rate links technology greatly to a top global of controlling the environmental impact of this type of activity. However, the lack of proportionality of skilled labor on the high seas, these investments still have vulnerable in terms of environmental enforcement, and the result should be determined by public authorities. The management criteria in the supply procedure, for example, every entry permit vessel in the territorial sea. The maritime service user ecologically commit to minimizing human impacts more harmful to the planet. It can manifest itself by voluntary direct payment to the owner responsible for this kind of eco-sustainable funding. At the beginning of the application of the surcharge to the market, it was perceived that the rate was equally applied regardless of the type of containers and shipping route. Currently, the practice of charging for ship owners, this rate varies per 40-foot containers and or 20-foot containers, Wherefore this last, the commercial practice of some ship owner require charging at least 50% of the 40-foot container rate. The fee was established to support the demand for quality fuel imposed in the ECA area to provide a technological way investments in resources to prevent particulate pollutants reduction arising vessels that generate in their production process emission greenhouse gases. Nowadays, in order to global governance model are growing demands for international convention, mainly in response to maritime operation with greater environmental impact in production, which takes place every longitudinal distance from the port of the transport, even search or in exploration maritime shipping in the various seas routes. Based on right of caution to the environmental damage in the activities of ship owners, demand a new supply rule in maritime operation in support of seeking positive results for the environment. Concomitantly, it is necessary to determine indicate environmental performance in terms of air emissions by a variety of tactics in maritime activities, mainly to prevent tampering by the naval oil and bunker suppliers, greatly choice of supply where there is need for new technological review of fuel quality at sea. Pragmatically, some ship owners receive some delivery notes for fuel without proper certification. This means that there is no descriptive contents about the product. Typically, these documents are substantive evidence that there is some uncertainty in some marine buyers on the credibility of the fuel oil with low sulfur content. According to the Chance IHS in 2014 via a report from the University of Cardiff, this practice has been observed by the maritime authorities, which gave even more reason to alert the environmental concern of emissions in the supply of these vessels is possible through quality fuel proof the environmental damage. For example, owners describe have brought 3,500 tons of heavy fuel oil or HFO and over 1,500 tons of marine gas or maritime gas oil or MGO. However, in reality, the owner bought only 200 tons of MGO, 4,500 tons of HFO. In this report, there are samples of bunker delivery notes and deviations that are evidence of illicit fuel, which is made by means of false tank allocation in vessels. Note that the problem of the accuracy of the inspection is already knowledge of the European Commission, which states that only 1 in 1,000 ships is inspected with regard to compliance with fuel quality control standards in EU ports. According to an executive of a major maritime amateur, the procedural control of the quality of marine fuel requires greater oversight in EU ports. Thus, it is believed that can politically be even greater diplomatic resilience, which would justify the current lack of enforcement because abusive practices by round vessels with flags of convenience. The most effective way to prevent such practice harmful to the environment can be the replacement of funding constraints of commercial activity per project's compliance practices. In this regard, what some Danish banks are doing in terms of the environment is healthily in business political practices. for having adopted compliance clause which will threaten cancel loans to errant ship owner, which prevent the encouragement of supply operation per illegal maritime practices. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.